This is Matt with ESI Survival Guide, an online resource designed to help legal professionals navigate the electronic wilderness. In this segment, we dive deeper into our conversation with Ariana Tadler. Ariana is the founding partner of Tadler Law LLP, a WBENC certified, women-owned boutique law firm that offers an array of litigation and legal counseling services. Ariana is considered to be one of the leading litigators in the country, with over 27 years of experience as an advocate for both plaintiffs and defendants across several practice areas, including all types of complex litigation, securities fraud, IP litigation, commercial litigation, toxic torts, employment matters, eDiscovery, class actions, and more. Ariana and her team have handled some of the largest and most significant data breach class actions in history. You can learn more by going to tadlerlaw.com. She's the only plaintiff's lawyer to be ranked repeatedly as a Band 1 eDiscovery practitioner by Chambers and Partners in the Global USA and USA Nationwide categories. She holds numerous leadership positions across the legal space, is a world-renowned academic, speaker, author, and lecturer in the space as well, and is the co-founder of Meta eDiscovery, along with co-founder and CEO Paul McVoy, who is also repeatedly ranked by Chambers and Partners in the litigation support category. He is one of only 9 eDiscovery professionals in the country that have received this designation in the 2021 rankings. Meta eDiscovery offers innovative, scalable, and cost-effective discovery management solutions for any size law firm. Visit metaediscovery.com to learn more. That's METAE discovery.com. The views expressed in this segment are those of the individual speakers only, providing content in their individual capacities, and are not those of their respective employers, colleagues, friends, family, or anyone else. The information presented here does not and is not intended to constitute legal advice. Please visit esisurvivalguide.com/disclaimer for more information. If you enjoyed this video and find it helpful, consider giving us a like, sharing it, or sending us a comment. And if you're interested in the intersection between law and technology and the amazing thought leaders, innovators, intellectuals, disruptors, personalities, and professionals that call this space home, subscribe to the YouTube channel. We are extremely grateful for your support and release new, creative, and engaging content as often as we can. Now let's get back to the conversation.
Let's pivot to that whole notion of the rules and developments in the rules. It's a completely different avenue. And I know there's a whole bunch of case law that shows still that dearth of understanding with technology and eDiscovery. I think a lot of that was on display. You saw a lot of commentary, although it's in the criminal context with the Rittenhouse trial. There was some confusion about just pixelation and zoom and some different technological aspects of the evidence in that case. Although while not particularly on point, it does highlight the fact that there's still this big separation on a very general level with the level of knowledge that a lot of legal practitioners have, and whether it's the bench, the bar, when it comes to technology. And, the federal rules, we're in kind of our second iteration from 2006 and 2015. You're front and center with these rules. What do you think is the state of adoption of the federal eDiscovery rules? Are they being utilized to the extent you expect them to be? Do you think there's still a wide chasm between adoption? I know that you were, of course, a very early adopter and actually incorporated means and methods to comply with these rules in your practice immediately, if not even before they came out. But what do you think is the current state of the practice of law generally and eDiscovery vis-a-vis those civil eDiscovery rules?
So I think that we have the lawyers who really spend the majority, if not all of their time in complex cases where they're either in the same few federal courts or even quite a number of federal courts across the country, but they're doing big complex cases. And big complex cases could be class actions. And class actions, by the way, could be federal securities fraud, consumer fraud, data breach, employment, any of those. You also can just have complex litigation, right? Business to business, what we say B2B. And so I think lawyers that have been practicing in that arena and are before judges that are solid case managers, which is what that Rule 15 package included, a push for judges to be active case managers. I think in that arena, you see everybody really putting those rules to the test, meaning using them responsibly and then pushing them out to their boundaries to see where is there some give, because there are some people out there who would like to make new law. The rules are rules, but they would like to see case law that says something specific about proportionality or potentially about specificity with respect to objections and RFPs, those kinds of things. That's an interesting space to be in, because for somebody like myself who likes to evolve, who loves the practice of law, who loves helping the law to evolve as well, that is a fulfilling place to be. It's not always a positive place to be. It can be frustrating, but it's constantly active, right? Then there are people that are out there who are practicing in federal court, and either they've never really practiced in federal court before, or yeah, they dabble in federal court practice and they really don't like the rules, or they don't know the rules, or they've never used the rules before and they're not going to start now. And that's where we start, I call that like, danger, Will Robinson, because suddenly it's like we could have a situation where somebody who doesn't know what they're doing creates bad law for the rest of us, when the rest of us are working really hard to refine the law in a way that is respectable, it's reliable. And so I think that's the dichotomy that I see. And we do have people who call my team at Tadler Law or our team at NetaE saying, oh my gosh, this is whom we represent, and the other side is insisting on this, that, and the other thing, and we want you to tell them no. And we say, okay, well, we need to know more facts first. Like, how did you get to where you are? Is this the beginning? Like, this is right before your Rule 26F conference, and you want to have some help or some guidance as to go there? Or did you have your 26F conference and there have already been discovery proffered by both sides and stuff has been produced and you already had some motion practice, and now you'd like us to come in and tell them why they're wrong? That's a half-baked cake, right? I can't necessarily fix the cake that you forgot to put the flour in.
Right.
On the other hand, if you come to me before the 26F, or even to help you with the 26F, we're putting the ingredients on the counter. We're saying, okay, these are all the ingredients we need to bake the cake. Let's figure out, do we want a chocolate cake? Do we want a vanilla cake? Do we want a very iced cake? Or we want, a pound cake? All those things. My point is coming in early, being able to work collaboratively with the person who's asking for the help, and then engaging with the other side and saying, hi, we're here now because our folks, our colleagues asked us to come and help facilitate this. And so that's a very different experience. I like that experience. I hope that I've never made anybody who comes to me who does not know the space or the law feel poorly or uneducated. I spend a lot of time wanting people to feel inclined to learn. So if you come to me and ask me for my help, I'm not going to just go run off with it and say, I'll tell you later. It's more, okay, let me show you why we're going to do this. Because in my mind, we have a responsibility to bring lawyers along. And it's true, those lawyers, they needed me. Why would I want to potentially push away the demand over time? On the other hand, I know what the vision is, and I know that there's a bigger demand out there for making sure that we constantly are getting the law right. And if I do it right here, either they're going to tell other people, or it's going to come out either through a court opinion or the adversary telling somebody else who's not doing well in a case. You might want to call Ariana or Paul.
Sure.
We seem to be at odds here. I think it's because maybe you don't have some familiarity with some of this stuff. Give them a call. Maybe they will give you some guidance.
Yeah, I almost wonder. I mean, I know that every legal domain has an academic element to it, of course, as there's bar associations and different groups and committees of all sorts and sizes. It seems like in the e-discovery space, we call it the e-discovery bubble, but that particular domain has a very robust kind of academic track that runs in parallel to the practice of law. And we see that at Georgetown, but also, like George Washington University Law School has that proportionality project. A lot of these things where some of the law that's developing on the case law then translates into, at least the good law, translates into academic opportunities that people can run with. And I'm wondering, for folks that aren't in the e-discovery bubble, how can they quickly change and maintain competence to keep up with how rapidly things change? I mean, I know you do it with extreme ease, but for different folks, I mean, would it be so much to ask, or do you think it would be a huge deal? I almost wonder if at the beginning of every case, rather than assign like a special master, maybe you do that. You have people sit down almost for like the safety video when they board the airplane. They have like an e-discovery CLE that they just watch for every matter that at least to get a semblance of what's going on. Because I do think that you're seeing a lot of adoption and a lot of folks definitely get it. But at the extremes, you're also seeing some really egregious examples of folks that are still committing certain bad acts, if you will, that to folks who've been in the industry for more than a decade, if not longer, are just flabbergasted that this stuff still goes
Yes.
on. How do you maintain your pace with the changes in the law and the case law in a practical way? I know everyone can just update templates that they have for various filings, but what else do you do to make sure you're incorporating new best practices into your actual practice?
So I really find that the conferences, whether it's a school-based conference or could be a not-for-profit, I find that programming, because it tends to be more advanced, I find that programming to be very helpful. And I have to admit, there were a number of years when I was sort of really in the thick of it, of my career, where, you'd show up to a conference, you had a speaking panel, and then I was back to my hotel room racing to get back to my job, my day job, and not spending the time in the conference. This last round with Georgetown, I couldn't go to every single panel, but I made a point of going to panels that I actually cared about, and made sure that I had put my phone down. I didn't have my computer open, that I was just really listening. And taking away from that, okay, what are some things I need to be thinking about to up our game? I'd love to say to you that I spend a lot of time reading every new article that gets written. I don't. I can only read so much. I'm trying to save my eyes for old age here. But I focus on what the bar associations do. And I do think there's so much content out there. I think you have to pick the places where you feel you're getting a takeaway. So let's think about bar associations, right? There's the ABA, then you have your state bar association, there are city bar associations, there are county bar associations. If we just stayed in the bar association arena, that alone, if you have an active practice or an active business where you're working lots of hours, as we're accustomed to doing, you couldn't even cover that landscape in its entirety. And so I'm not going to say that any one is better or best, but rather I think you have to go and test these places out and say, okay, you know what, this one resonates with me, this one resonates with me, and this one resonates with me. So I'm going to commit to those 2 or 3. And when I commit, I'm really going to be present. I'm going to make a point of being present. And the other ones that I used to go to, so this has been part of COVID for sure for me, coming away from, and again, we'll get to that joy factor, coming away from having so many shiny things to do and see, and saying, there are not enough hours in the day to do all of these things or to do all of them well. And so I just want to pick the ones where I know I will receive impact. There will be positive impact because I will be mindful. I will be present. I will want to listen to the content and kind of digest it.
Do you think it makes sense to work backwards from the, I guess you could call it the primary source material? So I think one of the byproducts of COVID from an academic standpoint is that you had this deluge of information because people now had time to sit down and actually get that article done, that book chapter written, that CLE prepared. At the same time, I think there's a lot of amazing, amazing content. There's also some content that maybe not be up to par, but I think the majority of it's really good, especially the stuff that comes from a lot of the tech developers and some of the more academic nonprofit associations. Could a survival tip for trying to navigate through just this deluge of information be to work back from the primary source material and to maybe focus on a couple of your practitioner, a couple of your clients, and really outside of the billable hour, maybe get more involved with their IT and information ecosystem, learn about what they have. And if they have Slack or Teams or they're using Zoom, to then use that as the signpost for where you might go and learn, well, I'm going to now do a program on Slack discovery. And now I'm going to learn how to collect from Zoom and use that to slowly build tentacles back into the case law and whatnot. Or is that maybe too specific of
No, I think that that's a really good strategic plan if your practice or your client base naturally conforms to that. So when I don't do exclusively plaintiffs work anymore, that's what I had done with our firm. We're a complex litigation boutique. So we do all sorts of work and sometimes we're on the other side, but we are known for our work on the plaintiff
Can I ask
side.
you real quick, has that been a struggle, separating yourself since you're such
No,
widely known?
no, I don't think so. If anything, I think it's made me a better lawyer all around. It's made me think about intention and impact, right? So my intention of what I say in one particular case, what's the impact? And if I said that same thing in a different case where I'm serving in a different capacity, will it have the same impact? Maybe not, because the audience is different, the client is different. And we're not spending oodles of time on the defense side. If anything, we're seeing more B2B or breach of contract type stuff where, yeah, somebody asserts the claim, but there are two people who have a dispute. And so I think being able to do that is actually more informative for my additional ongoing plaintiffs work.
Sure.
It gives more context, reminding me what was my intention in that case when I was serving as plaintiff's counsel and what was the impact? Now I've done something different. If I think back about that first case, is the impact that I thought it had different than now than what I thought it was then, right? Everything is perception.
I wanted to ask you, in addition to how you maintain being on top of developments in the law,